Hello, everyone, and welcome to the Federation of State Boards of Physical Therapy's last webinar of the 2022 year. And we're finishing up with a very important webinar from a local celebrity, well-known to you and to the Federation. I think many of you probably know celebrities that just go by a name. There's Jay-Z, there's Oprah, there's Bono, there's Beyonce. But around the Federation family table, we have a celebrity we just call Dale. It's my pleasure to introduce to you Attorney Dale Atkinson, who's going to be presenting to us on important regulatory cases and decisions that resulted from them. Dale, welcome to the FSBPT webinar series. Thank you.
Thank you, Michelle. I wasn't expecting that kind of an introduction, and so, but again, many thanks. And I don't know about celebrity status, but I'm here to share a little information and hopefully you all find it helpful. But I also look forward to your all participation as well. So we'll get to that in just a minute, but welcome to the December Regulatory Hour. And as mentioned, this is the last one of 2022. And so I encourage you all to as we roll into 2023, that if there are topics that you feel are important to you and from a regulatory perspective, feel free to put them in the chat or go ahead and send emails to Rich or Jeff or the staff at FSBPT. And so that helps us ensure that the information we do share is relevant to you all. So keep those cards and letters coming as well. So welcome. I'm here in Chicago, and it's cold here in Chicago. You know how cold it is in Chicago? It's so cold in Chicago that they caught some lawyers with their hands in their own pockets. So that'll be my starting story of the day here. So as many of you probably have heard, and as I start all my presentations, I do want to share a very sincere thanks. I do try to be funny and pardon my voice here a little bit. And I've been sipping on some hot tea here, but I do want to be very sincere in a giant thank you. Perhaps more importantly at this time of the year, but all throughout the entire year. Thank you to FSBPT and its board of directors for dedicating all the resources it does to assist you all and also to allow me to be a part of your world. Thank you to the staff for operationalizing these regulatory hours and all the other webinars that you all are participating in. Just a gigantic thanks to Bill and his staff, Rich and Jeff and others. But the biggest thanks goes to each and every one of you as a regulator, whether you're a volunteer board member, an executive director, administrator, inspector, investigator, assistant AG, or any role that you do play. It's very important. Regulation is not recognized enough. It's unknown by a lot of folks, not only licensees, but probably the politicians that are actually elected officials that are actually setting these policies. So a big thanks has to go out to each and every one of you. Your volunteerism is inspiring to me, and you all should be very thankful for what it is you do for public protection and what your organization FSBPT does, not only for you, but ultimately for public protection as well. So a gigantic thank yous to get us started here. As mentioned, I'm Dale Atkinson. I'm an attorney, and I represent a whole bunch of FSBPT-like organizations. These are not-for-profit 501c3 organizations, and I only tell you a little bit about me because you need to know you're not alone. And so you're on these webinars, you have the ability to communicate, take advantage of these types of networking opportunities and others. That's why FSBPT in part exists. And of course, it provides programs and services to you all that help lessen burdens on state government, which is why all of my clients exist. And so there's a community of regulators that you all can take advantage of, not only within the physical therapy world, but within other regulated professions, occupations, trades, whatever you call them, that do exist. And so I'm lucky enough to represent a lot of those. And hopefully in my 35 plus years of experience representing these groups, some of this knowledge will be helpful to you. We have chosen I have chosen to identify a bunch of cases here as we kind of round out this December decisions. And 2022 has been a year of alliteration. And so to get you all started here and to make sure you're all listening, you understand how the chat works, just type in the chat 1, 2, 3, or 4, how you're feeling right about now. You could be that sleeping lion or the dude standing on his head there, but This tells us that you're paying attention, listening. I see some sleeping lions there, so excellent. And so this gets you going and gets me going, and make sure that we learn to interact with each other. And so, regardless of how you feel, hopefully in the end you get a little bit out of some of our discussions and the information that we have here. So now, secondly, and this is pretty customary, I put a picture in here that identifies: is this Rich? Is this me? Is this Bill? Or maybe none of the above? And so. This is to keep you getting started here. And so we see some riches and some none of the aboves. And so you all are pretty savvy to these crazy pictures I put in. And it gets us started, gets us enjoying each other's company, gets us networking and otherwise. And so that was none of the above, by the way, just to let you know, unless it just happened to be Rich there. So lastly, now more substance now is type in one word that describes the most pressing issue facing regulators, perhaps in your world, physical therapy regulators, but maybe in general. And let's this is a good way for your organization to gather information about what it is you feel like is confronting physical therapy regulation. And this is hard to do in one word. I can understand that, but so we've got title protection, excellent, slow government. So I like how you're making them into one word, which is perfectly fine. And this helps us to, again, understand some of the pressures that you may feel you're under. And so legislation and consistency, these are all great words. And I encourage the FSPPT staff to gather these words, and we can create wordles. You can do all sorts of things with this to ensure that your organization is on top of the issues that do exist. And so, with many groups, by the way, the word that they type in is deregulation, politics, and others. And I saw a few of those that kind of zipped by: title protection and legislatures and others. And so take that to heart. And as we roll into some of these cases here, maybe some of the issues that are confronting you, we might at least address in the form of some of the legal opinions and the legislation that has recently surfaced. So what I plan to talk about is some judicial decisions that are relatively recent. Most of them are from 2022, that are identifying what I see as the legal issues of the year that will certainly roll into 2023. But I also have a splash of legislation that has been enacted and placed into law that provides us now with some of these important themes that are worthy of taking with you, if you will, as we navigate our way through the end of this year and then into next year. A quick plug, at least for myself, I suppose, or maybe Michelle would do this, but these bi-monthly, every other month webinars are going to continue throughout 2023. So I look forward to your issues, as well as some of these identifying terms and phrases, to make sure, as I've mentioned, that these topics are relevant to you. So since it is December, and I know some of you might celebrate Christmas, and for those that do, these two cases are from the early 2000s. And I find them kind of interesting, where in both cases, an individual tried to change their name to Santa Claus. And on the left there, the Utah case, as you can see, the Supreme Court reversed the lower court and held that the petitioner had the right to change his name to Santa Claus. And on the right there, an Ohio case, that the petitioner was not entitled to change his name to Santa Robert Claus. Both of these individuals said they look like Santa Claus, they act like Santa Claus, and they help children and all of these things. And so this is just an example of how courts can come up with different decisions. But a very, very quick story on the case on the left, in Ray Porter. Back when this case first came down in 2001, I used to start out presentations talking about a case that I thought was kind of funny. And this is a case that I chose. And I usually know my audiences. And so I thought, I can't make too much fun of this. And plus it's Christmas, Santa Claus, whatever. And I thought no one can be offended by this, but I didn't make fun of the case. I told about it. But anyway, I thought I'm safe. No one's going to raise their hand. And usually, like I say, sometimes I'll check to make sure that the attorney who argued this on behalf of the state from the AG's office, sometimes they're in the audience. And so I have to be very careful. Anyway. So I thought I was safe on this. I told about it, got a little chuckle. Okay, great, Santa Claus, and that you can change your name, at least in Utah. So a hand shoots up in the back of the room, and so I had to call on him, and he said, "That's my brother-in-law." And so he actually told us about the case and what was going on. And so I guess lesson to be learned that sometimes a case is there'll be people in the audience that know a lot more about it than I ever would. And so that kind of leads me to my issue of, if you all know about any case that I talk about or any other issue, and you feel that you would like to unmute and speak or type in the chat, either way, feel free to do that and expand upon some of the issues that may have surfaced in the cases and help us understand, make sure I'm accurate, number one, but help us all understand in case there's a little bit more information that you want to share. I will probably go kind of fast to keep us on time, but these slides are available to you. So Rich and Jeff, feel free to just distribute them as you see fit. And so let's start out with this Louisiana case. It's from 2019, but I thought I'd resurrect it again this year because, one, I really like this case. It's a good case. And two, is I think the name Bias is kind of cool that it's in the title, and that's the individual's name who was challenging it. But in short, to cover the facts of this, an individual is subject to discipline, an adverse action against a license. So it's an administrative adverse action. And as you all know, in many jurisdictions, that adverse action is issued by the board itself. There may be a hearing officer, there may be departments or hearing committees or others, but in general, this is done in an administrative setting. So here in Louisiana, the law actually says that the board shall consist of 7 persons, of which 1 shall be a physician. So we can now focus on the word shall. What does that mean? Is it directory? Is there leeway? Is it allowed to be interpreted in certain ways? And myself, who help write model legislation for most all of my clients, we focus on the words like shall, may, and others that might exist, must. And what do they actually mean? So as mentioned now, in this case, the statute says that there shall be a 7-person board, of which 1 shall be a physician. And the respondent in this case, who was a physical therapist who was under administrative investigation and ultimately a sanction, argued that there was a vacancy. And the vacancy was this physician. And the statute said there shall be a physician on the board. And this petitioner, this respondent, argued that, well, the board isn't fully constituted, so it has no right to act. And in the lower court, it was successful. The lower court agreed. Well, the statute says shall. Well, eventually, the Louisiana Supreme Court reversed that lower court and held that the language of the statute that said 4 members constitute a quorum somewhat, if you will, overrode the requirement that 1 shall be a physician. So as long as you had 4, it doesn't matter which 4, you have a quorum and you're able to act. So it cleared up a question that over the years, before I even knew about this case, I asked this question a lot. If it says there shall be 1 public member, there shall be 1 physician, well, what happens if there's a vacancy? And this case answers that question for us, and I think rightfully so, by the way, so that your boards aren't ground to a halt by the specificity of designated seats for individuals on a particular board. So, be that as it may, it was a plausible argument that worked all the way up until the Supreme Court reversed that lower court. So think about it now as you read your statutes, which you all should, by the way, as boring as they are, as poorly written as many of them are. As you read your statutes, words should jump off the page at you. And shall and must and may and others are probably words that will jump off the page at you, and you should have at least some working knowledge. Your lawyers will help you from here on out, but the issue here is really just understanding, are we fully constituted? And the last point I'll make about this is, well, what about vacancies? And do you have vacancies in your boards? Feel free to type in a yes or a no. And if anybody is willing to say, so yes, we've had a vacancy for the past 2 years or whatever. Sometimes these vacancies sit for longer periods of time. And we understand from a legal perspective that it may actually affect your ability to have a quorum, let alone this specific issue of filling a seat that shall be a public member or shall be a physician or otherwise. And so we know that the complexities of the law, and we know that the fact patterns can sometimes dictate when you can and cannot act. You have a 7-person board, you've got 2 vacancies, somebody has a flat tire or sick, can't make it to a board meeting, all of a sudden you can't act. So one thing I have been recommending to my clients, and I would recommend this to the FSDPT as well, as you look at your Model Practice Act, is that vacancies, actually putting this in your Model Act as a suggested piece of legislation, is that vacancies that exist for a certain period of time, 6 months, 12 months, whatever it is you all think is appropriate, if they're not filled within that period of time, that 12-month period, for example, is that the board fills the vacancy. So if the executive branch of government, which is how it works in most all your jurisdictions, is not fulfilling his or her responsibility to make those appointments, perhaps the board makes that appointment, and that keeps the pressure on the executive branch of government. I think that statute would be constitutional, meaning it would be allowed. But anyway, it certainly deals with issues about quorum, vacancies, filling those and otherwise. This is actually, and when I say a fun case, I'm not downplaying at all. It's actually a very interesting so-called fun case that I think answered a pretty important question in my mind as to how that might be interpreted, at least in Louisiana as well. So I see somebody just posted a vacancy of a physician member for 20 years. So imagine that, 20 years of a vacancy existing. And I see one above that about, yes, a public member. And that's where we usually see these public member spots sometimes aren't getting filled or through the appointment process. So understand the issues. And by the way, as a reminder, as I talk about cases, the issues are way more important than the answers. We all understand, well, gee, we have an issue here. It's a conflict of interest. So it's a vacancy. It's a quorum issue, whatever it is. If you understand that an issue exists, you'll get to the right answer eventually. Lawyers, parliamentarians, staff, board chairs, presiding officers are going to help get to those ultimate, if you will, answers, if that's the right way to phrase it. So issue identification, we talk about this in board training all the time. Issue identification, way more important than the answers. So make sure that you digest these fact patterns, start to see issues, and then I think they will resolve themselves. This is a 2022 case that is out of a federal court in Mississippi. And in short here, as you can see from the first bullet, the district court denied the defendant's motion for summary judgment. A motion for summary judgment, in short, is that a party is asking the court, the judge, to rule on the matter because the material issues of fact are not in dispute, so it's only a legal issue. We don't need to have a trial, a jury, or anything else, so that the issues of law can be determined and the parties agree to the facts. So that's, in short, what a motion for summary judgment does. But here, the court held that a plaintiff who was a physical therapist here was entitled to proceed with his complaint. So this case is going to go to trial, unless it gets settled, by the way, but this case is going to go to trial. Now, the fact pattern surrounding this particular case is that this physical therapist, basically stimulated by COVID, wanted to expand his practice and offer home physical therapy to homebound patients. And in order to do that, he had to get what's called a certificate of need, a CON, which are usually issued by a Department of Health. And these laws exist, I believe, in most all the jurisdictions and have since the 70s. And in Mississippi, and I believe in other jurisdictions as well, but in Mississippi, they've had a 40-year moratorium on issuing a certificate of need, meaning no certificates of needs have been issued in the last 40 years. Now, I think there's a few footnotes in this opinion where there have been some exceptions made, but in general, there's this moratorium. So this plaintiff, physical therapist, who wanted to expand his practice, had to get a certificate of need in order to expand that practice under law. It's codified into statute, by the way, and in Mississippi, I think it was done in like 1982. And so it's been around for a long time. Well, he wanted to get a certificate of need, but there's a moratorium on issuing them that's existed for 40 years. He cannot expand his practice. So you can see why he'd say, hey, due process, where are my rights here and equal protection rights under the Constitution, both Mississippi and the federal U.S. Constitution? So this will be an interesting case for me to watch. Is it regulatory driven? Perhaps not. But in the end here, we ought to know about what these certificates of need mean and how they might apply, because here is a licensee wishing to expand his practice which theoretically I'm assuming would benefit the consuming public, let's hope. But anyway, so this motions for summary judgment or motion on the pleadings basically is what I would call that. It was denied. So this case is going to go to trial, but for a settlement. So if anybody has any comments about certificates of needs that you want to type into the chat or unmute and tell us about, or if anybody from Mississippi has a little bit more information they want to add to it, it's an interesting issue that I think is worthy of following. So, and I think Jeff just posted a citation to the National Council of State Legislatures, which has charts about these certificates of needs. And the court actually in this case, the Slaughter case, cited the NCSL's charts and websites. So you may find some interesting information about where these exist and if they're still in existence. And I think the answer is going to be yes in pretty much all jurisdictions. And so Mississippi's scope of the requirement to get a certificate of need is broader, I believe, than most other jurisdictions. And so if anybody wants to unmute and chime in, feel free to do that as well. So kind of, as I mentioned, we're going to jump around. We're going to, identify some what I think are some really important topics, and probably one of the most important topics. And you all may not think it applies to you, but you as physical therapy regulators, but I think you'll be surprised by what is being litigated under this free speech First Amendment legal theories that exist. So let's start out right there in the heading of this is conduct versus speech. And so ask yourselves is what licensees undertake, is that conduct? Is that speech? Is it a combination of the two? Okay. And so you could take a profession, and let's move outside of physical therapy for a minute and talk about, say, mental health. Social workers, counselors, marriage and family therapists, addiction therapists, or others. And some of those groups I do represent. And ask yourselves, well, gee, is social work practice, conduct, or speech? And if legislation is enacted that either requires or limits, because remember, the First Amendment protects not only free speech, but it also protects compelled speech, where you may have to tell someone something versus you cannot say things. So both of those might exist. So anyway, so you have to decide, well, is this conduct or is this speech? Because that will dictate the legal theory that is guiding the courts in the issues that are brought up perhaps in litigation. So in this case now, so moving to this 2022 case, this Castillo case, it's a Florida case where an individual challenged the dietitian's regulatory scheme that exists. Scheme, by the way, not a bad word. The scheme that exists, meaning I must have a license to engage in activities that are within the scope of practice of a dietitian. And this person argued it's a First Amendment violation. It's merely talk with individuals. It's speech, and it should be protected, and it should be analyzed under First Amendment scrutiny. And all that means is, for the non-lawyers on the line, all that means is that you have a lot to overcome if you're going to limit speech. And there's thresholds of legal standards that must be met, okay? So if something turns from conduct into speech, the ability to uphold a limitation on that is very hard to meet from a legal standard. So that's the very, very short, non-technical legal version of this. So here, the 11th Circuit affirmed the lower court, so it's in federal courts, that's why it says 11th Circuit there, and it held that the statute in Florida that requires dietitians to be licensed regulated conduct with only an incidental burden on speech. So here the court basically said the First Amendment doesn't really apply, there's no violations here, and this statutory scheme of requiring licensure is can be upheld. And it was upheld here pretty recently in 2022. It was actually February of this year. But this kind of a challenge is happening everywhere. And I will say this, in the world of veterinary medicine, there is a practitioner in Florida. So you can think about veterinary medicine and make an assumption that's a hands-on profession, physical therapy, chiropractic, human medicine, veterinary medicine. Well, this individual in Texas is a 40+ year licensee. He allowed his license to expire, and he is practicing virtually only. And I believe, if I recall correctly, this Florida former licensed veterinarian has no patients in Texas, but he is physically located in Texas. So you can start to see, well, gee, there's a lot of issues going on here. Where does practice occur? And can this person practice? Well, so his clients are all over the U.S. and actually all international. There's a lot of international clients as well. But the Texas board cited him administratively for the unlicensed practice. And he's arguing now that what he is engaging in is speech. It's not conduct. It's protected by the First Amendment. His case lives on, by the way. And this isn't a profession that you all would probably say this is a hands-on profession. You got to lay hands on the animal in order to diagnose and have a plan of treatment in the event of a diagnosis. So interesting issues, but this conduct versus speech is all over the place right now. There is so much litigation going on that is trying to identify and differentiate between conduct and speech and when the First Amendment actually applies. So it wouldn't surprise me if it surfaced in other professions where you all might be surprised as to how does this apply when it's actually a hands-on profession. And so for those of you in physical therapy world, if you're involved with virtual assistance in any analysis or diagnosis issues or x-ray analysis or treatment options or anything else, and that's done virtually without hands-on, this argument might come up. And so it's something that my office keeps a close eye on. We do talk on this topic a lot of late. And so, it's something that you'll probably hear more about, at least from me, throughout the coming months. So I see when I was in Ohio, there were issues related to providing nutritional advice and whether you need to be a licensed dietitian to do that. So, so what Jeff is bringing up is a scope question. Is this within the scope or not? And so, by the way, kind of while I'm on that topic, this whole interstate practice issue, to me, there's only two questions you really need to ask and answer. One, is it within the scope? Yes or no? And two is, where does practice occur? That tells me where I need to be licensed. By the way, that second question, where does practice occur? It may be in multiple jurisdictions, where I'm located and where the patient's located. So there's a lot to unwrap on these conduct versus speech cases. And there's a lot certainly to see from a legal perspective. We will keep you updated and keep talking about these particular cases that exist. So now, while we're kind of into the speech issue, this is an interesting case as well. This is also relatively recent, as in September of 2022. And this is the Jones case. Deals with a pharmacist who was a rude person. Okay. Now, at what point in time does rude behavior turn into an administrative action where one's license may be at stake? Okay, you all can ask yourselves that question. If I'm a rude physical therapist or a rude lawyer or anything else, might I lose my license? And let's decide, well, gee, what's rude? I'm rude to the customers or the patients, or I say things that are so outrageously either racist or other things. It's a really hard question to decide. When do you all, as the regulators, get involved? Okay. So here, the Oregon Court of Appeals affirmed the board's decision to revoke this respondent, this pharmacist's license. So let's stop there. I'm going to be a broken record for just a minute because I've talked about the issue of verbiage and revocation. So ask yourselves, what does revocation mean? Okay, does that mean forever? In your jurisdiction, can you revoke permanently? Are you allowed to do that? And if so, the final order ought to say that. Or does a revoked licensee, are they allowed to seek reinstatement after a certain period of time, whatever it might be, a couple of years or something? It may be in your Administrative Procedure Act, but you ought to know the answer to that. And but for a permanent revocation, I am not a fan of revoking licenses, because I believe that it divests your board of the authority over this individual. Because you say you revoke my license, I continue to practice. Well, I have an unlicensed practice question on the table now. Do you all have the authority over unlicensed folk to administratively sanction someone? Most of the jurisdictions, the answer to that question is no. So be thinking about, well, what does revocation mean versus suspension? Can you suspend a license for 10 years subject to reinstatement rights, and you list all of them? So there are options here. So I always stop when I see the word revoke. It's used all the time. I think somewhat in a sloppy manner by the judiciary at times. But here, the decision was to revoke the license. Now, the court upheld the findings in this case. This was the rude pharmacist, and the judicial opinion here was did not explain the facts of the rude behavior. So I actually went and found the miraculously, by the way, I went and found the administrative ruling, which had a lot of the facts in it. And this pharmacist was rude to customers, called them names, referred to them as stupid. He used swear words and others, and he wasn't very nice to some of his fellow employees and some of the technicians and otherwise. So this is a bad dude. He's not very, polite, but there was no allegations of use of any words that it might be racial slurs or anything else. This is just rude behavior. And I'm now all the way full circle. Go back to my question. Well, gee, when does that become a regulatory issue? Is that the consumers can decide that and I go out of business? Well, maybe. When do you step in? This is a super important question, and obviously it's a speech question. And what you all consider rude may be different than what someone else considers to be rude. Here, this person truly was rude, but as mentioned, when does the board get involved? So what happened here is there was testimony. There was actually a hearing. There was testimony, and the employees said, here's what the pharmacist said. They described a lot of things. The pharmacist said, no, I didn't say most of that. Yeah, I called some people stupid or, whatever. He admitted to a few, but not others. And the court found that the witnesses, the techs and others who heard all this were more credible than the pharmacist. So they then ruled that, well, gee, the pharmacist wasn't truthful. That's what led to the revocation of the license, that he was untruthful regarding his actions. And that's a little different story, but this was all premised upon rude behavior. And I would suggest to you, as I already mentioned just a minute ago, is what's rude to you and me may be different. But there are lines out there somewhere. I don't know where they are, but when is it that boards become involved in matters that deal with speech, rude behavior, and otherwise, as opposed to malpractice, wrongdoing, injury, and others. So if you hurt someone's feelings or others. And so back to now wrapping up this particular case, since the court found, or the board found that they thought that this pharmacist was untruthful, that's what led to the revocation ultimately as well. So speech conduct, rude behavior, which is speech, and others. At what point do you all as regulators get involved? So as you can imagine, just a little splash here of some legislation. In California, the governor signed into law, and I believe this takes effect, it might be January 1st of 2023. This one, I can't remember now if this is immediate or not. I think I have a copy of it. But the governor signed into law legislation that allows for administrative disciplinary action against physicians who spread, quote, misinformation regarding COVID in the context of direct patient care. So this, again, is where I am suggesting that where the lines of misinformation versus disinformation, which versus false information, may be a little hard to find and hard to define and hard to draw. Now, misinformation, as you can see from the second bullet, is such that it's contradicted by contemporary scientific consensus contrary to the standard of care. Gee, what does that mean? Somebody's going to have to decide that eventually. And then you can read that, and is delivered with malicious intent or an intent to mislead. So that makes it a little more palatable in my mind under a First Amendment free speech enforcement side. But you can see here, attempts are eventually going to be made to try to draw these lines as to misinformation, and COVID has driven, of course, a lot of this. But at what point in time does this start and stop? So I'm not advocating one way or another. I'm just bringing to you the attention of legislation that exists that you all may be asked to enforce as regulators, as board members, and then obviously perhaps as staff of board members. So difficult lines to draw. California is setting the stage here, and this is happening in other jurisdictions as well. That one is pretty recent. October of 2022 when it was signed. So this next case out of Indiana, and by the way, I am always searching for cases that are relevant to the professions to which I am speaking, and there aren't that many physical therapy cases. So one, apologies for not talking about all physical therapy cases. I would do that if I could find them. And then two is, however, you take these cases and digest them into your worlds and figure out, well, how does this apply to me? So revocation, free speech, rude behavior, and here we're going to get into expired licenses. So you all can make them applicable to your worlds. But again, this is a case from 2021, super important case in my mind. I think it's just the wrong decision by the Court of Appeals of Indiana. I don't agree with this decision, but let's talk a little bit about what happened. Elmer was a pharmacist. He was indicted criminally for some bad behavior related to drug diversion and otherwise, including money laundering and other things. So this was a bad dude who eventually was criminally convicted. But in the midst of all of this investigations and otherwise, which, by the way, a quick side note, when you have behavior that you're administratively investigating that might implicate criminal activity, your investigators are very cautious about coordinating with law enforcement so that they don't step on any toes or create any evidentiary issues that may not be able to be used in the criminal matter. So that's just a particular as a quick aside. But when you have concurrent administrative investigations and criminal investigations, there's a lot of caution that has to be exercised by the administrative investigators that undertake this. So this dude was eventually convicted, but what happened in the midst of all this investigation, he allowed his license to expire/lapse. Okay, and the board continued its administrative investigation, and it eventually revoked his license, which was expired. So the question on the table for the court was, can the board exercise its jurisdiction over an expired license by revoking it? And the Court of Appeals here held that and you can see from the first bullet, it affirmed the lower court, so it said the lower court was correct, and held that the pharmacy board did not have jurisdiction over an expired license. So I think it was a bad decision. The court justified this by saying, well, if this guy ever comes back, tries to seek relicensure, that's when the board can finish up, if you will, its analysis of the wrongdoing and decide to perhaps not give a license, not grant it or not reinstate that license. Okay. I think that ruling, by the way, ignores the fact this licensee may be licensed in multiple jurisdictions and any data that needs to be shared either through the FSBPT data bank or through the National Practitioner Data Bank or otherwise. And so knowledge out is extremely important. I think the court ignored that. But so now the questions I will bring to your attention are, well, what do you all do if I don't renew my license? Okay. You probably have a grace period, maybe. Okay. Maybe you never hear from me. And then what? Grace period runs out. I would suggest that you all enter a final order that said Dale's license is now, and then you tell me the word: lapsed, expired, terminated, whatever you think, revoked, whatever you think is the appropriate word. And that should be posted on your website. Now, I will say this, back to that Oregon case, the rude behavior guy that I had to go find the administrative order, it was not easy to find. It is very difficult for me, and I know what I'm looking for, to find information on websites of regulatory boards. So to the extent you have the authority to make your websites user-friendly and chocked with information that's relevant to the consuming public, I would suggest that you do that if you can. But I understand that's not an easy task. But so now back to this. So I allow my license to expire. I don't renew it. You never hear from me. You have no idea where I am. I would suggest you enter a final order that says Dale's license is expired, terminated, lapsed, revoked, whatever you call it, post it on the website. So the public now knows that my license is no longer valid in the jurisdiction of blank, whatever your jurisdiction is. And I don't think that happens. And I represent a lot of professions, if you association of boards like yours in a lot of professions, and this discussion stumps a lot of people, or there's not a lot of uniformity as to how this is handled. So one is all the way back to the beginning. This is your chance to network with each other. Feel free to type something into the chats or otherwise. And this is also the chance for you all to identify issues in intrastate. So, for those of you who are from Wisconsin, you can talk to other boards in Wisconsin. Well, what do you guys do with lapsed licenses, those that don't renew? And you can talk intrastate in addition to the interstate, same profession that the FSPPTs facilitate like this. So I don't know the answers to that. Feel free to type them in here related to how you handle a lapsed or expired license after the expiration of a grace period and what goes on here, at least in Indiana for right now. Regulatory boards don't have authority over an expired license to take an adverse action against such license. So comments or questions while I take a quick drink? Somebody has to unmute and say something, and you might win dinner for two at your favorite restaurant within your jurisdiction. FSPPD is happy to send out those certificates. So so administrative suspension posted on the website. The final order is not issued. That'd be a good idea. Oh, excellent. So thanks, Mindy. That's a good follow-up / comment to that. So we have a couple more cases, and then I would, I'll at any point in time, if you have something to say about what's going on in your jurisdictions, what's important to you, and what you're thinking about rolling into 2023, feel free to get ready and go ahead and do that. So here is an award of attorney's fees. So everybody has to understand that there's this potential for an award of attorney's fees to a prevailing party. Okay. And so we have to decide, well, what is a prevailing party? When can they be awarded? And in some jurisdictions, it only flows one way, is that the board can collect its certain fees when it's successful in administratively prosecuting someone, but the respondent who is successful in offsetting an administrative prosecution may not get attorney's fees. So you should know the answer to that question: who's entitled to seek them? And we all know that attorney's fees can be rather expensive. I did have a potential client come into my office and ask me the other day what it would cost to answer 3 questions. I said, oh my God, I forgot my joke now. Okay, forget the joke here. I'm going to keep going here. I'm not trying to make you all laugh here. So anyway, this is an important issue related to the consequences of a successful or unsuccessful administrative prosecution. So in this case, the respondent is another pharmacy case. Apologies for all the pharmacy cases, but these are the ones that are rising to the top in the world that I work in. So the respondent filled a prescription. There's a whole lot of facts that go behind this, but the board said that she filled the prescription without an appropriate prescription from the practitioner. I happen to be a veterinarian, by the way, which is another group I work with. But the board prosecuted this and was unsuccessful. Okay, and rightfully so. By the way, if I had time, I'd tell you all the facts. But rightfully so, this person, in my mind, should not have been administratively prosecuted, because she took every step she could to ensure that this prescription was valid, including calling the veterinarian and then writing down what the veterinarian said. She gave the script, she filled the script, gave it to a tech who was supposed to scan it into the system. The tech didn't scan it in. So when there was an audit done, there was a prescription filled without a corresponding written prescription that was in the system. So that was the short version of the facts. And the Idaho Supreme Court, in this case, affirmed the lower court, held that, and this is a complicated case, but held that the petitioner's petition for attorney's fees was not timely filed. So what happened in the administrative matter, the board was unsuccessful, okay? And under the statute, it says that you shall award attorney's fees. There's that shall, by the way, we've already talked about. Attorney's fees and costs if it finds that the non-prevailing party acted without a reasonable basis in fact or law. So here the Idaho Board of Pharmacy not only held that it couldn't prevail in its administrative prosecution, it held that we as a board acted without a reasonable basis in fact or law. So this respondent pharmacist was entitled to attorney's fees. You have to seek attorney's fees under the statute within a certain period of time. It was 14 days. This attorney did not do that. And 207 days later, filed a petition for attorney's fees. The board said, sorry, you're too late. They had a fight about that and the board won, okay? Because there was no justification for the late filing of the petition for attorney's fees. So, there's a lot that went on factually in this case. But the short version for you all is, well, gee, when can attorney's fees be granted? What are they? And then can you have costs here as well? And in this case, attorney's fees should have been granted, but they didn't file the petition in time. So they did this respondent who was successful did not get her attorney's fees reimbursed. And so you can see there, by the way, that bottom note there, the Supreme Court awarded the board attorney's fees because the appeal they thought was without a reasonable basis in fact or law. So this really turned, not only did this respondent not get attorney's fees, but had to pay the board's attorney's fees related to the appeal. Did that all make sense? Somebody shake their head, yes, give me a thumbs up. So as long as you could follow that. The fact of understanding when they can be awarded, you all ought to know, by the way, the difference between costs and attorney's fees and fines. Okay, so fines are intended to punish and deter future conduct. Costs, fees, attorney's fees, and others, those are intended to reimburse the board for out-of-pocket expenses related to an administrative prosecution. And both of those have to be in statute. You have to have the statutory authority to impose these. You cannot give yourself a rule or even a policy that allows you to impose attorney's fees. So make sure that you know what the statute says. Your lawyers will help you with this, but this is an issue identification matter that you should know. So I see it prevailing as an interesting concept. We prevail on 2/3 of a writ of mandate, but we're responsible for more than the 2/3 of the cost of the respondent. So yeah, if you're successful on some and not on others, you may have to do some calculations, and it's likely the court will help decipher what those are. So you're right. If you have 6 counts and you're successful on 5, how are you going to figure this all out? Or if you're unsuccessful on 5, how does the respondent figure all that out? So it can get a little complicated. So a couple more slides here. One is legislatively now. I think we all should understand that the movement around the country, is to address good moral character issues. There's legislation pending in a lot of jurisdictions that is either trying to limit or eliminate how good moral character is assessed in a licensure application and potentially renewal situation. So Arizona House Bill 2612 removes, and this is pretty recent. I didn't put the year in, but it's I believe it's from 2022, relatively recent. It removes good moral character criterion from all initial licensure applications. And so, so thank you, Mindy. She says, yes, it's this year. And what I think the legislature was trying to do here, and Mindy, feel free to chime in or unmute and speak, and that is to eliminate the discretionary issue of good moral character. It identifies that criminal convictions are separate and distinct criteria. So this nebulous good moral character based upon historical events that may not be criminal in nature is what I believe the legislature is trying to say. That's not part of licensure. You cannot base a denial of licensure on this nebulous good moral character factor. But if you've got a convicted felon with a heinous or serious crime, that could perhaps still form the basis for a denial of licensure. So it's trying to eliminate this discretionary issue. Unfortunately, I think legislation like this is Dale's editorial opinion, is that because they don't trust boards. They don't trust the regulatory boards to regulate a profession. It's a bunch of physical therapists sitting around a table regulating the physical therapy profession. It's all one happy family. And can we really trust them? Right? That's one way to look at it. And you can flip that around and say, you're keeping people out because you want less competition, so you can make more money or whatever. There's a whole lot of arguments that can be made here. And we as the regulatory community, you as regulators, whether you're a public member or a licensee who's on the board, we have to have the trust of the legislature. We just absolutely have to do that. And a lot of that trust was thrown out the window when the North Carolina State Board of Dental Examiners case came up and the antitrust laws were disputed and others. That was just the board being accused of protecting its own. So anyway, so that was a little tangent off to the side here. So there's a lot of legislation that is not only looking at good moral character, but it is also saying criminal convictions can only form the basis under certain circumstances. So there's a lot of legislation out there that might say something like any criminal convictions over 5 years old cannot be considered as a licensure, as a basis for denying licensure. It might say 10 years. It might have a time period in there. And others might say, in order for a board to consider a criminal conviction, it has to be related to the practice. And that's troubling language for me because I don't know what's related to the practice. And there was a physician case many years ago where a physician was selling automatic weapons out of the trunk of his car, and the board stepped in to take his medical license, and the physician said it's not related to the practice of medicine. So, and there's probably merit to that argument, but it is a felony, and that defense did not work for that physician, but be that as it may. So there's a lot going on in the good moral character world. Keep your eye on that and others. Here in Illinois, where I am, this case or this legislation was interesting because in a 119-day period from introduction to signing into law, the legislature approved the removal of the BSW social work licensure examination, an entry-level competence examination as a criterion for licensure. They did it unanimously, passed both chambers of the legislature without a nay vote. So that tells me that I don't think necessarily that these legislatures know what an entry-level competence exam is, what it's intended to do, how it's validated, how it's measured and otherwise, but it did happen. It became effective in January of 2022, but the fact that it moved so quickly through the process and was supported, by the way, and if you will, sponsored by the trade association, the state chapter, which is really surprising to me, but it tells us what the legislatures may be thinking and may be doing. And I think, as I mentioned, it certainly indicates in my mind a lack of understanding of why there's an education component in law and why there's an exam component. These are two very, very different issues. This is a good topic, I think, for perhaps a 2023 webinar, but understanding the difference between education and exams and why the exams exist and how they're validated. So as we wrap up here, happy holidays to everybody. I do want to say the regulators rock. For those of you guys know that there is a group called the Regulators, and a gigantic, huge thank you to all of you for what you do for regulation and ultimately for public protection. Please remember, FSBPD is your organization. Participate, network with each other, get groups together both intrastate, other professions, and interstate within physical therapy regulation. But you guys rock. A big shout out, applause, and thank you from me to each and every one of you. Are there any comments that anybody would like to make? There's a few in the comments here about they're discussing the exam issue related to bias and social work and should they be dropping in others. And so anybody have any comments about anything either I talked about or that you think is important that you want your fellow regulators to hear? Feel free to unmute or type it into the chat itself.
Dale, while people are thinking, the case about the rude pharmacist got my attention. In your examination of the details in the notes behind that case, was this a pattern of behavior and it finally resulted in revocation of the license, or was this a one-time complaint that resulted in a pretty serious response?
If I were to, well, first off, to answer your question directly, it was a pattern of behavior. It was not a one-off time. So there's a lot of stuff that this dude said, according to the witnesses that testified. So, and then quickly jumping to the First Amendment side is, gee, at what point in time does it become actionable? If I call somebody stupid or something, or hurt someone's feelings. So it's a tough issue, but it was a pattern. It happened over the course of a long time. So,
but previous complaints had not been brought to the board about this individual. This was a singular complaint that resulted in revocation.
I think there were multiple complainants, and they came from coworkers. Wow. So I think one complaint stimulated others to file, and kind of escalated from there. But I don't believe there are any complaints from a consumer, a patient. And as I emphasize, the basis behind the complaint by my issue is at what point does the regulatory board become involved? Rude behavior and others. And so there's a doctor case where the judge wrote a really fun opinion. I can't remember the name of it offhand. This is not that long ago, just a couple of years ago, where the judge started his opinion about Dr. So-and-so had a very, 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 very bad day, or whatever. There's a children's book about having a very bad day. And then it was kind of the same thing. This doctor was tearing a phone off the wall and slamming the copier and stuff. But these are interesting questions. So if there are no other comments, I am proclaiming right now, 2023 is Regulator Appreciation Year. So Happy New Year to everybody and holidays. And I will turn this over to Michelle. Here's my many, many thanks. And Michelle, take it away. And again, thank you all for having me.
Dale, many, many thanks to you. We'll always still use your one and only name, and we'll know who that is and appreciate you for it. A couple of points. Dale mentioned that he'll be doing the seminar series again in 2023, of which we are delighted to learn. And also our next presentation will be January 17th. See if I can pull this up. For a speaker who was unable to be with us in the annual meeting, Jake Nichols will be doing a presentation on opioid and substance abuse. And it sounds like it's incredibly contemporary, too contemporary. And I hope you can tune in January 17th at 4 o'clock. So with Dale's bid for happy holidays, I too will send you off with my best greetings. This is Michelle Thorman signing off from the icy banks of the Mississippi River, where the fish are slow, the fishing boats dream of spring, and the fisher people still are filled with stories. Thank you all. Have a good holiday and a good, blessed 2022 and 2023.